morning, counsel. All right, counsel, I wanted to deal with the two motions that were filed by the state. And one was to admit evidence of bias, the testimony related to union membership, and Officer Potter being a former union president. Mr. Frank, would you like to be heard on that issue?
Yes, Your Honor. Thank you. Good morning. Our motion is, well, let me back up. As you know, the court will instruct the jury that when considering how much weight to assign the testimony of witnesses, one fact that the jurors may consider is the relationship of the parties. And our motion, therefore, or in that vein, is addressed not at union membership, period, or as a whole, or in general. Our motion really has two purposes, but both based within the specific context of this case. So we're not seeking just in general to say people in unions, you should consider their testimony differently. It's the context of this case, Your Honor. And if our motion was not specific in that regard, I apologize, and I'll try to add that precision now. The specific context here is a union that provides services and defense for its members when they are questioned about their job performance. And those are very serious matters. They're often very serious matters, as we know. And so that sort of defense, that assistance, is a little bit different than a lot of unions. This case is about an officer's conduct, and so in the sense that when people worked with Ms. Potter, they felt that as their union rep or president, she had their back. The question is whether witnesses that are still a part of that union or were a part of that union when they knew her might feel like they should have her back. I'm not saying that's true. I'm saying that's a question that the jury should decide based on that evidence. So that's one purpose for that. Not to cast aspersions, of course, on unions or anybody in particular, but it is part of the relationship of those two parties that is tied to the allegations in this case. The second basis upon which this motion is brought relates to a specific witness who we expect to testify, who is currently, as we understand it, working for that union that provides defense. And so we certainly, if that's true, intend to ask him about that, because it would be no different than the defense hiring an investigator to come in and testify to facts. We would put in that they are paid to do that. And so if that witness is going to testify about the conduct, we think we have a right to inquire about that relationship as well. So those are the limited bases upon which we sought to admit that evidence and submit that it is relevant to the issues at hand for the jury's consideration. If they assign it no weight, that's their prerogative.
Okay, here's the problem that I see, and I'll let the defense respond as well, but Officer Potter, former Officer Potter, is no longer connected to the police union in any way. So witnesses that are testifying couldn't possibly be biased to testify in her favor because of her position.
I think the point is that over the years, there was a relationship between Officer Potter and other witnesses who were in the same union that had the same interests. And as I said, it's not just that they worked with her, it's that she had this additional role in defending them and providing services to them. In that sense, they were more than just co-workers. It's a stronger potential bond, and that should be something the jury gets to know about when they're considering the relationship of the witness and the party.
Okay, Mr. Ng.
Well, the evidence is that former Officer Potter was the union rep for 2 years. What is critical here is that they're attempting to show a relationship that doesn't exist. Tim Gannon, the chief, was not in the union whatsoever. Sergeant Johnson wasn't in the union. Acting Chief Grenning wasn't in the union. So there's really no connection. And her role was essentially to negotiate a labor contract, pay and leave and that sort of thing. And it was quite limited. It's not like the Minneapolis police where there's a very powerful union rep that we've read about, for example. So there's no showing of bias, and the individuals they're concerned about weren't in the same union anyway.
Okay. Did you want to respond, Mr.?
Just 2 quick points, Your Honor. Officer Johnson would have been a member of the union until, I think, 2015 when he became a sergeant. And Tim Gannon is currently employed by that union. And he will, as has been represented to us, will come in and offer opinions, thoughts, and so we think it absolutely relevant that he is now employed by the union that also employs legal defense for officers.
All right, I'm going to find that the questions about union membership and Officer Potter's former activities in connection with the union are not relevant to show bias. So I am denying the motion of the state. The second motion the state has is to preclude quote, improper lay opinion testimony. And would you like to briefly be heard on that, counsel?
Yes, Your Honor. Thank you.
Thank you.
Your Honor, the defense had disclosed 2 expert witnesses in this matter, Dr. Miller, the psychologist, with respect to their theory on slip and capture, and Mr. Iams with respect to use of force. What they have done since those disclosures is essentially try to turn other cops into expert witnesses. The court heard from Sergeant Johnson on Friday. Sergeant Johnson testified to issues with respect to use of deadly force, application of a statute, things that are particular legal conclusions that are outside the scope and improper lay opinion. The parties had discussed this with the court sort of beforehand in chambers. It was an issue that we raised. The way that this went down on Friday was extremely prejudicial, but also extremely improper when it comes to the way that lay opinions might be used under 701. Under Rule 701, a lay witness may offer lay opinion testimony on issues that are sort of common everyday occurrences. That does not include things like legal conclusions, things that require particularized or specialized knowledge. They don't, of course, encompass things that are ultimate issues for the jury to decide, including whether or not deadly force is reasonable, whether or not any particular force that was used was reasonable in this case. Those are issues for the jury. Those are issues that are central to this case, not proper for lay witness testimony. Because of the testimony that was heard on Friday, of course, the state has now asked that the court prohibit any further inquiry along those lines and ask the jury to disregard those specific opinions that were outside the scope of any lay witness. The concern as well is that the defense has also provided some disclosures with respect to their anticipated witnesses. That includes former Chief Tim Gannon. It appears that he may also offer similar opinions with respect to whether or not the use of a taser was reasonable, whether or not the use of force was reasonable, his review of video having not been a part of that interaction whatsoever. And it also appears from their disclosures that he may ultimately try to offer opinion with respect to their slip and capture theory, which again would be improper, whether or not she experienced any phenomenon that would be what they're trying to describe as a slip and capture. Your Honor, obviously if we had known that this was where they were going and these questions were coming out to that extent on Friday, it's something we would have raised again in the moment, but of course we are now in a position where they have blown open this door. This was not a question just about what happened on that day and what did you see and what did you do. There were questions about, does this statute apply? When does this statute apply? All of those call for legal conclusions. All of that is improper lay testimony, Your Honor. So we have concerns about what has been done. We'd ask for an instruction that the jury be told to disregard those types of opinions, but we also want to make sure that those are properly limited going forward with respect to the witnesses they intend to call. Thank you, Your Honor.
Your Honor, we object to that motion. We ask that it be denied. It was their witness. I cross-examined the witness. I did not ask about any statute. He's the one that brought up the statute. If they didn't prepare the witness correctly, that's their problem. In addition to that, they never objected at the time. So now they want to redo the testimony that the jury's already heard. It's actually proper lay testimony as far as a witness goes, because his perception is there. He was in the vehicle. He said he was, and he has that's a rationally based perception under Rule 701. Helpful to clear the understanding of the witness's testimony or the determination of the fact and issue. Well, he sure was helpful. He was there, and he gave his opinion as to what Kim Potter did was reasonable. And that's a lay opinion. And it's not based on scientific, technical, or other specialized knowledge within the scope of Rule 702. I'm reading from Rule 701, Your Honor. It's proper evidence. We did not have to give them notice, oh, by the way, we're going to cross-examine your witness with these issues. They should have known that since he's given statements. I didn't pull this out of the clouds. They had taken statements from him that say these things. So we adamantly object. They didn't object last week, and now they want to redo the trial. Thank you.
Okay, Ms. Aldridge?
Thank you, Your Honor. If I may respond briefly to that. When it comes to Rule 701, 701 is a rule that allows for lay witness opinion on matters for which they have personal knowledge. So things like, what did you see? Was the car speeding by as it went by? Things like that. In this case, what the defense has done is asked Sergeant Johnson on Friday, and presumably will ask additional witnesses, to assume and speculate what was in the mind and known to Officer Potter, former Officer Potter, at the time these decisions were made. That is not a personal opinion. That is definitely not a lay opinion, and it's outside the scope of that rule, Your Honor.
All right. Anything further?
Well, Your Honor, they didn't object. I cross-examined the witness. There was no objection at all. There wasn't anything last week.
Okay, first of all, Officer Johnson's opinion, I am not going to tell the jury to disregard. When that issue came up, I ruled that police officers can testify about what they have been trained to do under certain circumstances. There appear, the defense, I think the state's motion goes beyond Officer Johnson. They're also trying to preclude any of the police officers that will be testifying in this case from issuing or eliciting opinions concerning whether or not the use of the taser was appropriate under the circumstances. And I believe that the police officers, due to their training, are entitled to render an opinion on that. And it's totally appropriate for them to do that. So, I don't know if there were other areas that the state had a problem with respect to expected police officer testimony or not.
Your Honor, we did. It was not just whether or not the taser was appropriate, but there were opinions about whether deadly force would have been appropriate, and also with respect to the psychological components of whether someone would experience things similar to slip and capture.
Okay. There is no question that no witness, including the defense expert witness, can testify that Officer Potter experienced action error or slip and capture. Nobody can say that. But I'm not going to preclude any of the officers from testifying that based upon their training and experience, deadly force or use of taser was appropriate under the circumstances. Okay. Is our counsel ready for the jury?
Judge, can I be excused from that? I forgot my water.
Yes, you may.
Thank you.